Hello, I'm Julian Whittle from Cumbria Chamber of Commerce, and I'm here with Tom Scaife, a partner and employment specialist with Baines Wilson, to discuss the General Data Protection Regulation, or GDPR for short. Tom, GDPR comes into force on May the 25th. What is it and why is it coming in?
Well, in very simple terms, GDPR is the EU's way of updating how we all go about safeguarding people's personal data. The reason it's coming in is because the previous EU directive that covers data protection is actually 23 years old now,
Right.
So that came out in 1995. When it was actually put in place, it was quite static, so it didn't really look forwards to how the world might change. And if you think, Julian, about how the world has changed since 1995, Facebook didn't exist, Google didn't exist, things like Friends Reunited have come and gone, and the whole landscape of how we all deal with data is completely different. Just as another example, we've now got the Internet of Things, so we can tell our kettles to switch on from remote locations. And all of this creates a bit of risk as far as how our personal data is used.
So for clarity, if it's an EU regulation, will it still apply after Brexit?
Yeah, it absolutely will still apply after Brexit. First of all, it comes in before Brexit happens. Secondly, I think the UK government in general has said that at least for a while we're going to maintain all the laws that we get from Europe, but also on this specific issue, the UK government has said we are actually proud of our stance on data protection. We've always been an example of best practice, and actually we want to comply. The last point on that is most businesses in the UK will continue to process data in relation to individuals within the EU, so they would have to comply with it anyway, just for that reason.
So GDPR supersedes the Data Protection Act. How does it differ from the Data Protection Act?
Okay, so when GDPR takes effect on the 25th of May, it's going to bring in a variety of new elements. So it's not the way we operate in the UK currently. We have a baseline which is set by the Data Protection Act as to how we deal with people's personal data. There's also best practice. What GDPR is going to do is it's going to make what is currently best practice in the UK the sort of minimum standard, and it's going to bring in new rights. So, for example, data subjects are going to have the ability to request that they're forgotten, so that's a right of erasure. There's going to be significantly more onus on organisations to be able to demonstrate accountability and compliance if needed, and probably the biggest single shift is it's going to require organisations to be far more transparent with individuals about what they actually do with their personal data, why they collect it, how they store it, everything that they do with it.
Now, this concept of personal data seems to be central to GDPR. What constitutes personal data?
Okay, so it's any data about an identified or identifiable living individual. So rather than getting hung up about it, businesses will be best placed to just think that if anything can identify a human being, including somebody's name, that is personal data. It's actually quite a simple concept. It's anything that you could use to identify somebody.
Okay, now GDPR talks about data controllers and data processors. What's the difference and what are the implications for each of them?
So a data controller, that's somebody who is, again, in fairly simple terms, they're in control of that data. So the personal data that they collect or they take in and they process, they actually determine what the purpose for holding that data is. They determine what is actually done with it. A processor, on the other hand, might be, as an example, where you're outsourcing services. So you might provide personal data to a website host so that they can put stuff out on your website. You might outsource it data for payroll purposes, for example, to accountants. They will be processing data on your behalf, and so you're still in control of telling people what to do with it, but you're still the controller. The obligations are actually fairly similar for each, insofar as both controllers and processors will now have obligations to make sure they safeguard the data, make sure they only process it for specified purposes, and quite importantly, everybody's going to be on the hook as far as getting it wrong.
Right. So how will GDPR enhance data security, and what are breach notifications?
Well, as an absolute baseline, GDPR says that now organisations are going to have to put in place adequate security measures to protect the data. That sort of exists now, but one thing it is changing is that organisations are going to have regard to the state of the art when they're putting in provisions. So it's no good to start collecting personal data and then think a little bit later about whether we can put adequate security measures in place. We've got to think about it from the absolute outset, and we've also got to make sure that our security measures keep up to date. So just as a very simple example that I've been giving to clients in the last couple of weeks, we're probably all guilty of getting that little pop-up box on our desktop that says, do you want to update your virus software, or do you want to update Windows? And you click the box that says remind me later, because actually you've got better things to be doing. But GDPR, in very simple terms, brings in obligations to make sure that all your systems are kept up to date, and those security systems are actually adequate for the purpose. There is a bit of a risk element to that. So if your processing activities are low risk, then yes, you'll have less of an obligation to put in place, obviously, Fort Knox type security. But what you have to put in place is directly correlates to the risk involved. So
if it was simply a list of email addresses, the bar wouldn't be as high as if you were holding bank account details, for example.
Yeah, exactly.
Yeah. And what about breach notifications?
So this again is something new that's coming in with GDPR. If you have a data breach, which means losing the data, or it's being destroyed by accident, or it getting into the wrong hands, there is now going to be an obligation to notify the Information Commissioner's Office. This will only apply where there is a risk of harm to the rights and freedoms of the individuals whose data has actually been lost. The really important thing here is the ICO is really your friend. I see the ICO's role.
That's the Information Commissioner's Office.
The Information Commissioner's Office is everybody's friend. It's sort of there to help educate people about GDPR and data protection, support them when there's a problem. I would always say, if you've got a data breach, pick up the phone to speak to the ICO, even if you have to do it on a no-names, anonymous basis to begin with. Take some guidance from them about what the breach is and whether they think it's worth you notifying. If it's worth notifying, then do so, and do so within 72 hours of the breach. They will help you to contain it, and you might have to, in some circumstances, send out notifications to customers so that they can take steps as well. So if you think about recent issues, I know Equifax, for example, they had an issue involving hacking where they passwords for customer accounts got out. They were a bit slow on the uptake, but eventually they've sent out emails to customers saying you need to change your passwords, and that's the sort of thing that the ICO will help to contain.
What rights will individuals have to access the information that businesses might hold on them?
As with the case now, individuals will be able to make a subject access request. So currently they can do that anyway. You've got 40 days to respond. If you are so inclined, you can charge them a £10 fee for the benefit of that. Moving forwards, you'll no longer be able to charge a fee, and you'll have to respond to that subject access request within 30 days. What the subject access request, again, in very simple terms, enables the individual to obtain is details of the personal data that the organisation has and a copy of it. There are some limited exemptions that businesses might be able to use to wriggle out of providing everything, but under the GDPR, the individuals are going to be entitled to receive copies of more information.
And does that apply to employees as well? Will they have rights to access information that their employer holds about them?
Yes, absolutely. It's exactly the same, and actually, employee data is one of the biggest categories of personal data that most businesses will have. So, an employee can make a request in exactly the same way, and it's fairly common, I have to say. Obviously, I'm an employment lawyer. It's fairly common for employees, when they're involved in a dispute, to whack in a subject access request just for sometimes for a bit of devilment, sometimes for a bit of fishing to see if there's some evidence they're not aware of. So yeah, it does happen, and actually that is where the majority of the subject access requests come from.
Okay, now we've got less than 3 months now before GDPR comes in. What should businesses be doing in readiness?
Okay, so there's actually 84 days to go as we sit here today in a snowy Carlisle. Now is absolutely the time that people should be doing something. The first thing that organisations need to do is undertake a data audit. You can only really reverse engineer GDPR. You need to know what data you hold before you can decide how you're going to comply. So that means interrogating your data, having a look at what you've got, why do you hold it, and that's both the practical business reason for needing it, and also under GDPR there's a variety of legal bases that you need to rely on to be able to process information. So, for example, a lot of people are going to rely upon one of them being legitimate interest or performance of a contract. So you need to identify what that legitimate interest is. You need to think about where you hold the data and where you keep it. Are there adequate security measures in place? Who can access it? And also, you need to think about who you actually give it to. So are there any third parties that you might provide that data to? That's really important to do all of that, because then just in doing that you can identify vulnerabilities in the security of the data.
Yeah.
You can also identify whose data you've got and what it is, so that you can actually inform those individuals exactly what data you hold about them and what you do, because that's one of the main things that GDPR is bringing in. It's this obligation to actually provide to individuals from the outset information about what you're going to take about them, how you're going to use it, why you're using it, why it's necessary, and what you're going to do with it.
So you have to tell them that before GDPR comes in.
You'll need to be ready when GDPR comes in to be able to inform people about that, whether it's via a privacy notice, for example, on your website, or a privacy notice that you give to employees and put in your handbook, or contracts of employment. Whatever medium it is, you're going to have to come up with a way of actually getting that information out to the people whose personal data you process.
Now, we've known GDPR has been coming for at least 2 years, but in your experience, in general, are businesses ready, or are many still in denial about this? Are they still unprepared?
I think most businesses, as we sit here now, aren't ready. I do think that most businesses are aware of it. There's certainly not many people I've spoken to who aren't aware of it. GDPR, it's one of those few bits of the law that's actually kind of made it into mainstream news. So it's in everybody's mind. So that's good, and it is useful to get people thinking about data protection. But no, the actual turning the mind to dealing with how are we going to get ready for this hasn't really happened yet, but it is happening, and I'm certainly we're fielding a lot more queries now from organisations asking us to help them, whether it be checking documentation that they've drafted, or actually just drafting everything for them, or doing training. So this week I did a training session for a client, the same session 3 times in a day on GDPR. So more and more businesses are now starting to engage with it and realise that they've got to get on with it.
You spoke a bit earlier about the Information Commissioner. Is it the Information Commissioner's Office that's responsible for enforcing GDPR?
Yes, it is. So in the UK, the Information Commissioner is our authority for doing that. Each European member state has their own authority. So there'll be a variant of the ICO across all those states. It's fairly easy in the UK. If there's a breach that involves UK individuals, then it'll be the ICO that looks at it. Where it gets a bit more complicated is if it's a cross-border breach. So, if you've got 500 individuals in the UK and 500 in Germany, for example, then there's a bit of a bun fight to be had about which authority actually deals with it. I know there are provisions in the GDPR for fighting that out amongst themselves, but yeah, that's the only time that it could get a bit more complicated.
Now, I've read that the penalties for non-compliance could potentially be severe, up to 17 million or 4 times annual turnover, whichever is the greater. I mean, that sounds really extreme. Do you expect that the Information Commissioner, initially at least, is going to be lenient and take a softly approach on any transgressions?
Yes. There is no way that the ICO is going to run out on the 25th of May and investigate all data breaches and issue £17 million fines to everybody, partly because I don't think the ICO would have the resources to be able to investigate everything, and secondly, the ICO has been absolutely clear about this. They've said GDPR is not all about hefty fines. It's about making everybody think more about how we inform people what we're doing with their data. Just to put some flesh on that, the last year of that statistics are available for, the ICO completed 17,300 cases involving data breaches. They issued fines in 16 of those cases.
So
a tiny proportion. They've been absolutely clear. We're not looking to change our appetite for enforcement by way of issuing fines. And also, the maximum fine at the moment is £500,000. They've never issued that. The most they've ever issued is £400,000 for some of the most serious breaches involving really personal data, sensitive personal data that could cause significant harm. So no, it's not about issuing fines. The ICO is there to help guide and help contain any issues, and that position is not going to change.
Not going to change. So where can businesses get more information about this?
There's a variety of sources. The best place at the moment to get up-to-date information is via the Information Commissioner's website. They've been caught a little bit on the hop with this. The ICO is going to be issuing codes of practice which have statutory effect and sets out how organisations have to deal with the data that they hold. They also issue guidance notes. Unfortunately, the final draft of the GDPR was late, which means that the UK Data Protection Act, so that our new Data Protection Act, is late, which means that the ICO's guidance is also going to be late. So everybody's a little bit behind the curve on it, but that's the best place. Obviously, there's other organisations out there that can provide advice. We provide advice. Happy to have initial chats with people. We also send out alerts if people want to sign up for those on our website. But just one note of caution on this. There's so much misinformation doing the rounds about GDPR as well. I had a client send me a link to a YouTube video the other day, and I took exception to what was being said in it, and that was from a fairly decent authority, or should have been an authority on the subject, and that was about marketing emails. So it's important to make sure that you get your information from the right sources.
It's interesting you mentioned marketing emails there, because I'm receiving personally quite a few from organisations that saying we need you to update your preferences, otherwise we won't be able to send you emails from May. Is that the case then? Is that something else businesses need to be wary of?
This is something that, again, as far as misinformation is concerned, there's two different parts of legislation that impact upon sending marketing emails out to people. So the first one is GDPR. That's going to come in, and that means that in order to continue to process marketing information, you're going to have a legal basis for doing so. As I've said earlier, actually a good thing to rely upon is legitimate interests in those circumstances. So another of those bases is consent. You can rely upon consent. If you've got somebody's unequivocal, specific, informed consent, then you will be able to use their details for marketing to them. But actually consent can be withdrawn. So I would say don't rely on consent for marketing. Where consent is absolutely relevant is in relation to something called the Privacy and Electronic Communications Regulations. They actually came in 2003, and in very simple terms what they say is that you can only send marketing emails to individuals, so that's consumers, not businesses, if you have consent to be able to do so. Consent for that can either be they've opted in, so they've given you consent to do so specifically, or you can rely on something called a soft opt-in. So a soft opt-in is where you sold something to them, or you were negotiating with them to sell them something, whether it be a product or a service, and at the time that you did that, you told them that you were going to provide them with marketing information. You gave them the ability to opt out, and every time you've sent them something subsequently, you've also given the ability to opt out. If you have those two elements of consent, you can send them marketing emails. That's the case now. If you don't, you can't send them marketing emails. And the ICO has been really clear about this, and they've said that if you send them an email now, these are the people you don't have consent for. If you send an email now saying GDPR is coming in and we think we need to update your marketing preferences and get consent to be able to email you, you're sending them marketing emails, and you're already in breach. So you're in
right.
You're in breach of a bit of legislation that's been in for 15 years. GDPR doesn't affect it, and that is something that is causing quite a lot of confusion amongst the businesses.
Okay, thanks very much, Tom.
Okay, thanks a lot.